The parol-evidence rule bars evidence of collateral oral agreements to alter the terms of a written integrated contract. Regardless, the defendant in Brinderson-Newberg Joint Venture versus Pacific Erectors argued that the parties had verbally agreed their contract didn't actually mean what it said. General contractor Brinderson-Newberg had a contract to build a power plant. Brinderson negotiated with subcontractor Pacific Erectors about handling part of the project, a large pollution control system. Brinderson believed that Pacific's bid covered building the complete system, but Pacific wanted to erect only the support steel for the system. Brinderson and Pacific met multiple times and reviewed the proposed contract line by line. The contract obligated Pacific to, quote, erect complete, unquote, the pollution control system. The contract listed the specific components that Pacific would erect to, quote, make a complete installation, unquote. The contract also contained an integration clause. Pacific asked Brinderson to change the contract to say that Pacific would only pick and set the system components and Brinderson would install them. Brinderson refused. Brinderson maintained that Pacific ultimately agreed to erect the whole system. But according to Pacific, Brinderson promised to interpret the contract to limit Pacific's work to erecting the steel structure and picking and setting the components. Pacific claimed that Brinderson assured Pacific that one of the contract's boilerplate introductory clauses limited Pacific's scope of work to the type of jobs Pacific customarily performed, meaning picks and sets. Both parties performed under the contract until Pacific refused to erect the system components. Ultimately, Brinderson sued Pacific for breach of contract. At trial, the district court admitted testimony that Brinderson promised to interpret the contract to limit Pacific's contractual obligations. Brinderson denied this allegation and objected that the evidence violated the parol-evidence rule. The district court denied Brinderson's motion for directed verdict, and the jury found for Pacific. Brinderson appealed to the Ninth Circuit.